Whether you're a new franchisor, an emerging brand, or a 200 plus unit franchise system, it's inevitable. You're going to have non-compliant franchisees. So how do you deal with them? How do you enforce your franchise agreement? And how do you put in place a robust franchise compliance framework and system for getting your franchisees to comply, to enforce your franchise agreement, and to grow your franchise system? Franchisee compliance, there's so much more involved than just sending legal notices, default letters, non-compliance events, and attorney disputes. Franchisee compliance, it's about the stability and growth of your franchise system. It's how you treat your franchisees, how you coach them when there's events of non-compliance, how do you get them to conform to your requirements, and how do you legally protect your franchise system? And so when we talk about non-compliant franchisees, well, we're talking about franchisees that either are violating an express term or provision in your franchise agreement, or they're not operating the right way. They're not following your system standards. They're not following the specifications in your operations manual. They're just not operating the business the right way. So those are non-compliant franchisees, and how we deal with them as a franchisor is what I'll call our compliance systems. So right now, as a franchisor, you should be working with your franchise attorneys to map out, document, and create an ever-evolving compliance system for addressing non-compliant franchisees. And what are these compliance systems? Well, they're the business steps, the operational steps, and the legal steps that you have in place that you're going to take to address and deal with non-compliant franchisees. From everything as basic as an operational default that may not be impacting system standards, to significant defaults where the franchisee is not using proprietary products or just outright breaching and violating their franchise agreement. So our compliance systems, it's our process. How do we address non-compliant franchisees? How do we document their non-compliance? When do we elevate their issues to a legal default notice? And how do we maintain and safeguard our overall franchise system? Ultimately with the goal, compliant franchisees, following system standards, great customer products and services, a growing franchise system, increasing royalty revenue, expansion, and growth. That's the ultimate goal. How do we approach franchisee compliance? What are some safeguards we need to put in place when we're developing a compliance system? Well, there's 4 factors. We should be fair, we should be consistent, we should be legally compliant, and we should be proactive. So those are the 4 things I want to focus on. Those are the things we focus on with our clients as we develop different scenarios of how to respond to franchisees, what type of notice we're sending, when do the notices escalate to a legal default, and potentially termination of a franchise agreement. So as you develop your franchise compliance process, I want to keep those 4 standards in mind: fairness, consistency, legal compliance, and being proactive. And then map out, and this is going to happen and evolve. If you're a new franchisor or an emerging brand, this is going to evolve over time. As you encounter franchisee non-compliance events, you're going to work with your franchise counsel, and we're going to map out different strategies and processes and systems to put in place. Now, when dealing with non-compliance, I think it's important to understand there's really 2 levels. There's non-compliance events, and then there's defaults. A default is when a franchisee reaches a level where there's a clear violation of the franchise agreement, and legally we're confident as franchise counsels say, hey, we can send out a specific legal notice notifying the franchisee that they're in default of their franchise agreement. And the next step is for them to cure, if it's a curable default, and if not, potentially to terminate the franchise agreement. Whereas operational non-compliance, maybe it hasn't risen to the level of a default yet, or maybe it'll be multiple non-compliance events that create a default. But generally, it's helpful to consider when you're dealing with non-compliance, operational non-compliance, and then things that rise to a level of a default. And in fact, I would say there's 4 categories of non-compliance that you should be considering: a payment default, an operations default, an operations non-compliance event, and what I'll call a technical non-compliance event. And let's discuss these. Payment default, that's pretty clear. Your franchise agreement states franchisee has certain payment obligations, royalties, brand fund fees, technology fees. So a payment default is a very clear breach of the franchise agreement. The franchisee is required to pay something to you, a royalty, a brand development fund fee, and they just haven't paid the fee. And so it's a very clear default. It's objectively provable. Franchisee hasn't paid their payment obligations. That's a payment default. An operations default is also a clear breach of the franchise agreement, where it's very clear a franchisee is not meeting system standards and is jeopardizing the uniformity of the brand, or is jeopardizing brand standards, where they're going to not only impact their operations, but also the reputation of the franchise system as a whole. So an operations default, they're just not doing what they're supposed to do in the operations. And these could be a bunch of things. These could be some defaults specified in the franchise agreement, or a franchisee's failure to follow standards in your operations manual. Examples: pre-opening, franchisee fails to obtain a lease on time. Franchise agreement may say franchisee needs to lease an approved location within 9 months. We're at month 12. Well, that's an operations default. After that, the franchisee fails to lease a location on time. Operations default. Once the franchisee is operating, are they not following brand standards? Are they substituting proprietary products? Are they not spending their local marketing dollars the way they should be, or in the amounts they should be? Are they not following operation hour standards, right? Are they closing the business? These are all operational elements that could rise to the level of an operations default. Now, operations noncompliance is one step below an operations default. It's where franchisees not following standards, but maybe it's not impacting the brand, or maybe it doesn't relate to our proprietary products. And examples being they're not meeting certain service standards. Maybe when we do an inspection, they're not meeting inspection standards. Maybe as to non-proprietary products, things that aren't proprietary to our system, but we designate a specific vendor, they're not purchasing from that particular vendor. Maybe even things like their customer reviews, or when you do an on-site inspection, they're not meeting standards. Those are operational non-compliance events. And those are events that typically you want to notify the franchisee about, provide an inspection report, advise as to where there was a failure to meet standards, advise as to corrective actions, but doesn't yet rise to the level of an operations default. Now, maybe over time, 1, 2, 3, 4 operations non-compliance events, their failure to cure what they're required to cure or change their can rise to the level of a default. And the last category that I suggest you use is technical non-compliance. The franchisee operationally is not meeting every standard, but the standards they're missing are very technical. They're not impacting the brand. They don't impact supply chain. Maybe they're promoting and adjoining businesses. They're engaged in activities really not harming the brand, but something you don't like. Now, how would you gauge a technical non-compliance event? Well, where if we're before a judge, they'd say, well, that's really not that big of a deal. Certainly, not serving our proprietary products, or not buying our proprietary products from our designated supplier, or not buying even non-proprietary products from a designated supplier, in time becomes a default. 4 categories I want you to keep in mind: a payment default, that's obvious and objective, they just didn't pay what they're supposed to pay; an operations default, where, hey, you're seriously violating our standards and you're impacting our brand and jeopardizing the quality of our product and our reputation; or even operations default, you didn't do what you're supposed to do. You didn't lease a location, you didn't open up on time, you're not open during the hours we specify, you closed the business for a certain number of days, you're not serving our proprietary products, you're purchasing inferior product from an unapproved vendor. Those are operations defaults. And then we have operations non-compliance events. They're important. They could impact our brand, but it hasn't risen to the level of a default yet. And we want to notify, we want to create conformity by the franchisee, we want to educate and coach them. And then technical non-compliance events where, hey, we could notify the franchisee, but we don't want to go to war over it, right? We don't want to provoke litigation. And certainly we want to coach our franchisees to success. So consider those 4 elements, or those 4 types of non-compliance events: payment default, operations non-compliance, and technical non-compliance. So what are the best practices? What's the best way for dealing with our franchisees when we're faced with these situations? Well, when we build out our franchise compliance process and we consider, okay, how do we respond to this franchisee? How do we notify the franchisee? What instruction do we give the franchisee? Does this rise to a legal letter from you, Charles, where your firm is sending a default notice, or should this come from our team? and notify the franchisee, hey, we're sending you this operational notice. You failed to meet specifications on items A, B, and C, or you failed to pass our inspection on this date, attaches our inspection report, and here's the corrective measures we'd like you to take. And these are all forms and processes we build out with our clients based on your specific brand. So what are the boundaries? How should we approach our franchise compliance framework and processes? Well, we want to be fair. We want to be consistent. We want to be legally compliant. We want to be proactive. And we want to do all these things with the primary goal of creating successful franchisees and growing our franchise system. And with the secondary goal of legally protecting you as a franchisor. So let's start off. Fairness. Everything we do, every notice we give the franchisee, from a compliance perspective, will have a legal impact and a system impact. Legally, a franchisee attorney, and naturally, we don't necessarily care what franchisee attorneys think, except we want to discourage them from looking at our franchise system. We don't want them to be encouraged to sign a retainer with our franchisees to harass us. So everything we do from a compliance standpoint on fairness, consider will be viewed by the franchisee, potentially a franchisee attorney, and if eventually we get to any litigation, by a court. So we want to create a record of fairness. Second is system impact. How we treat a franchisee will be viewed by other system franchisees. And your franchisees need to see and perceive that as a franchisor, you're acting fair. So we want to be fair. How do you do that? Every franchisee is different. Well, I think we need to distinguish between severity of the franchisee's action. Are we dealing with something that's a clear default and a very high magnitude, right? Because that's objectively provable. It's very clear. You didn't pay your fee, you're in default. You didn't open on time, you're in default. Versus a non-compliance event where franchisee didn't hit system standards. Maybe it was cleanliness in a restaurant. Maybe it was service delivery. Maybe it was following up on customer leads. Those are not as objectively provable as, say, a payment default. So we got to distinguish between defaults and non-compliance events. Evaluate the severity, right? The more severe the franchisee action, the more severe our action should be. And second is we need to evaluate whether or not the franchisee is acting in good faith or bad faith. Is this the franchisee's first violation? Or is this the second, third, or fourth violation? If the franchisee is acting in good faith, even with things like a non-payment default, and they're trying, and maybe their default is just simply that the business is not performing, but they're making every effort to meet system standards. Well, from a fairness standpoint, especially if this is the first time, we need to treat that franchisee differently from the repeat offender, the franchisee acting in bad faith, the franchisee who's been told on numerous occasions that they're purchasing, non-proprietary products, or that they're not meeting system standards, or that they failed 3, 4, or 5 system evaluations or on-site inspections. So we want to evaluate the severity of, are we dealing with a default or a non-compliance event? And we want to know about the good faith or bad faith of the franchisee. So step one, we're evaluating fairness. If the franchisee is acting in good faith, if this is their first offense, well, then maybe our compliance systems, the practices that we set down together, or that you set down with your franchise council, maybe, and one that I'm going to recommend is, let's not send a default notice on day one. Let's document the default or the failure on the part of the franchisee. Let's send them a friendly notice, maybe a non-compliance notice from your corporate team that we'll work on together, advising the franchisee of his or her obligations under the franchise agreement, advising the franchisee how he or she defaulted, and advising the franchisee as to the corrective measures they need to take. Also, for this good faith franchisee, I'm going to recommend that your corporate team contact and communicate with them and say, hey, we're going to send this notice to you. It's not a default notice right now. It's a non-compliance notice that we're sending to you. You haven't done A, B, and C, or you violated 1, 2, and 3. We want to check in and see how we could help you. We want to document what's going on and see if we could take corrective measures together. That's how I'd recommend dealing with that good faith franchisee. And that even may be the case if it's a payment default, right? This is their first time defaulting on payment, or maybe multiple, and we need to examine if we need to support them better and if there's some corrective measures that we could help with. Conversely, if we're dealing with a bad faith franchisee, second, third, fourth offense, it's clear they're not following system standards. They're just shutting the business down weeks at a time. They're serving unapproved products. They've received operational or non-compliance notices, and they haven't taken any corrective measure. Well, in that case, the next step is going to be a legal notice. And what we would be doing is evaluating, is it a default? Is it an operational default? Are we required to give them cure? So from a fairness perspective, as we're implementing your franchisee compliance program and processes, we want to, number one, evaluate the magnitude of the violation. Is it serious? Is it objective? Can we objectively prove it? Or is it a high-level operational default that we need to notify them now because they could damage the brand and brand reputation? And then two, is the franchisee, is there a first offense? Are they acting in good faith? Are they trying, but maybe we have some business issues, versus a bad faith franchisee, someone who's received multiple notices? So in our compliance program, that's how I recommend we evaluate fairness. And our fairness evaluation is going to evaluate what triggers. When do we send a legal notice from our firm or from your franchise counsel? When do we send operational non-compliance notices? How do you follow up about coaching? Do we go straight to legal? Second step that we need to, or framework we should always keep in mind as we're building out franchisee compliance processes and systems, is we need to be consistent. Consistency is key. The number one complaint, whether legitimate or not, that franchisees and their legal counsel make when they're attempting to attack a franchisor is somehow that franchisee is being treated from others. They love to use the word disparate treatment. There's a legal reason. Certain state laws prohibit disparate treatment. And so we want to keep that in mind. But franchisee attorneys, franchisees, every other word will be disparate. They will bring up 5 other instances where you didn't pursue another franchisee and you're only pursuing them. So you need to be consistent. And I see this issue often with new and emerging franchisors. There's that lack of consistency because you build some trust with franchisees, you let things slide, you don't document processes, you think a franchisee is going to conform, they don't, and then all of a sudden, a year later, everything repeats and now it starts escalating. But you never documented your prior practices and you're not being consistent. I've seen brands where they have a problematic franchisee and they may claim a default. Either the franchisee didn't renew the franchise agreement on time, or the franchisee's not following system standards, or a host of other actions that the franchisee may or may not be taking. And as a franchisor, you're incentivized to pursue a default against them because you feel like the franchisee is not good for your system. But if you're not consistent how you treat each of your franchisees, it will become a defense that a franchisee will raise, their attorney will raise, and if it goes to litigation that a court would consider. Why are you defaulting this franchisee on A if you have 3 other franchisees doing the same thing? So you want to be consistent in what you're doing. Next is you need to be legally compliant. The most important thing for legal compliance when you're dealing with franchisees, whether or not they breach the franchise agreement, not meeting operational standards, not compliant, is you need to document. You need to document, even if we're not defaulting a franchisee, you need to create a record that you advise the franchisee that they're not meeting system standards, that you contacted them, you gave them corrective measures, and that they didn't perform. So earlier I mentioned one of the biggest issues we see, start a franchise relationship, a franchisee doesn't comply with certain elements, you have a conversation with them, but you don't document it in writing. You have a conversation, they start complying again. 6 months passes, they fail to meet system standards again. You have another conversation, you talk to them, they're problematic, but you're not documenting it, they comply again. This goes on and on for another year. 2 years later, these defaults continue, the franchisee gets worse, and you're fed up and you tell your legal counsel, let's send a default notice. And hypothetically, say you do send the default notice. That franchisee will act as if this was the first time you ever communicated this to them. They'll ignore or forget that over the past 2 years, you've consistently communicated with them, they haven't complied, and now you're fed up 2-3 years later and sending a default notice. The problem you have as a franchisor is you didn't create a record. Think about it. If you ever got to litigation over this issue, or if the franchisee's attorney contacted me or your legal counsel and say, why are you defaulting my client? Imagine how powerful it is if I say, Well, look, over the past 2 years, we've sent 6 operational noncompliance notices to this franchisee advising of this exact same issue and advising them of the corrective measures. And they haven't taken it, or they did, and now they're in violation again. And so now they're in default. We're in a much stronger position because we've documented all of these steps. So I recommend, your franchise compliance process should be about documentation. Even if you don't want to default a franchisee, even if we're dealing with an operational non-compliance event that you believe will be cured, or had a great conversation with the franchisee, it should be documented. A non-compliance notification, a non-compliance report with corrective measures, even a polite phone call to the franchisee saying, hey, this isn't a legal notice, but it's important for us to document our processes and our systems and our working together. And so you send them that notice. That becomes part of your compliance record. That becomes very important if the franchisee falls out of compliance in the future. And it's also important, the documentation, for informing and coaching your franchisees. Remember, the first goal shouldn't be let's legally default them. We want to create compliance. There's nothing better than a written statement advising them of the non-compliance event, corrective measures, and certainly by putting it in writing increases the magnitude of importance. It's important for you. You've documented it. It'll be more important for the franchisee. So we want to be legally compliant, and part of legal compliance is we need to document, to inform and coach, and create a record. Other measures we need to evaluate for legal compliance. We need to check our operations manual. While your franchise agreement includes certain clear standards about operations and service standards and retail standards and how you want the business to operate, many of your system standards will be identified in your operations manual itself. And so to be legally compliant, we want to make sure our operations manual is consistently updated, that it's clear, that it's communicated to the franchisees, that it's available to the franchisees. Other issues, legal compliance. Before our firm ever defaults a franchisee, there's 2 things we check. Number one, what does your franchise agreement say? Is this a payment default? If it's a payment default, do we have to give 10 days notice or 30 days notice? And let's send out our notice. Is it an operations default? If it's an operations default, can it be cured under the franchise agreement? If it can be cured, is there a notice period? Is it 10 days notice? Is it 30 days notice? Who are we sending the notice to? Who are the owners? What's the notice address for the franchisee? So we're checking the franchise agreement. There's another thing we need to check though. Depending on the franchisee's state of residence and depending on where the franchisee operates the franchise business, we need to check that state's franchise relationship laws. So just like we have franchise registration states, and many of those franchise registration states and others have franchise relationship laws. And these franchise relationship laws are laws at the state level. They're designed to supplement and enhance protection of franchisees. For example, states like Illinois prohibit disparate treatment, right? Earlier we said be consistent. New Jersey has New Jersey Franchise Practices Act, which requires certain notification requirements before you could terminate a franchise agreement. And there's a number of other states that have franchise relationships laws. So just because your franchise agreement says you could terminate or terminate on 10 days notice, that may not be the case, because if you're in a state or if a franchise relationship law governs your relationship, you need to check those laws because they may supersede the terms of your franchise agreement. Now, in our framework of creating our franchise compliance program and practices, we want to be proactive. You don't want to be reactive. We don't want to have a non-compliant franchisee who's making a number of operation non-compliance events over the past year or past 2 years or past 6 months, and then 12 months later, attempt to send them a default notice and attempt to terminate the franchise agreement. Although maybe that's going to be an option, but that's not achieving the overall goal. We want to be proactive, so we coach and guide franchisee behavior, franchisee expectations, the appearance of fairness with other franchisees to improve our franchise system. Ultimately, we don't want to be litigating or defaulting franchisees. We want compliant franchisees that are performing, paying royalties, increasing system value, and building a better organization and better brand. So we want to be proactive. So much so to the point where we have clients where even before the franchisee opens the franchise business, they start asking for a P&L. may have very little activity. Well, number one, it's good to see what the franchisee is spending pre-opening, construction, build out, and things like that. But the most important element of that is you're coaching a franchisee into compliance. You're teaching the franchisee that they need to report to you, that they need to maintain records, right? So the worst thing to do is to not be proactive or not be consistent, where one day you don't request reports or you're not following up with franchisees, and the next day or 6 months later, you have all of these new requirements, and franchisees are getting mixed signals about what the franchise system is all about and what their obligations are. So keep in mind, we want to be proactive. We want to be proactive to the goal of coaching franchisees and their behavior to elevate and grow the franchise system. Ultimately, franchise compliance practices and programs, it's all about avoiding legal disputes, making our franchise system less attractive to franchisee attorneys, disincentivize them from looking at our franchise system, document so they see there's a clear record of documented history, consistency, fairness, proactive. And overall, that enhances the enterprise value of your franchise organization. So the elements of a good franchise compliance process. Well, number one, we want to understand the magnitude of what we're dealing with: payment defaults, operational noncompliance, technical noncompliance, and how we address and deal with those events. Well, number one, we want to be fair. We want to consider who the franchisee is and whether they're acting in good faith or bad faith. We want to be consistent in our actions, in our requirements, how we treat franchisees. We want to avoid disparate treatment. We want to be legally compliant, which means we need to document and keep documenting. And then we need to follow our franchise agreement, franchise relationship laws, and we need to be proactive. This is not about litigation. This is not about legal arguments. As franchise counsel to many brands, my primary goal is to avoid litigation. You're building a franchise system. You're building an amazing brand. You want to improve lives. You want to improve the lives of your franchisees. We want to be avoiding disputes. We want to elevate. It's almost inevitable. You're going to have non-compliant franchisees. You're going to have franchisees where we're terminating their franchise agreement. Hopefully it's a mutual thing. Hopefully it's amicable, but we want to build our system and we want to build our processes so we legally protect your franchise system, and a franchisee attorney or franchisee attorneys don't interrupt or interfere with the entrepreneurial journey of your franchise system and your compliant franchisees.